Before we move on to estoppel, this last section on consideration talks about the rule that the consideration must move from the promisee, and we'll also discuss non-bargain promises. Let's discuss the rule that consideration must move from the promisee first. This simply means that the benefit must be conferred or the detriment incurred by the promisee if he wants to sue on the promise, and not by someone else. Tweddle versus Atkinson, 1861. The fathers of a soon-to-be married couple promised to pay soon-to-be husband a sum of money upon the marriage. The consideration for each promise was the promise of the other, which means the bargain was, I will give him some money if you do too. After the wedding, the bride's father neglected to pay the money, but the court held that the husband could not sue for the promised money because the consideration was provided by his own father by promising to do the same thing and was not provided by the son who was trying to enforce the promise. His father, the promisee, could of course have sued. We have been mainly discussing bargain promises, or where there is a benefit incurred and detriment suffered by both parties. Now let's discuss non-bargain promises. These promises are where the promisor does not request anything in return. He promises for free, for nothing. For example, because I love my niece, I promise to pay her £100 tomorrow. She does not have to do anything in return, and I have not asked her to do anything. Should she be able to enforce my promise against me? The promise in Combe versus Combe was not enforced precisely because the husband had not made a bargain that in return for his promise to pay his ex-wife, she would refrain from applying to the courts for maintenance. She did that of her own will, and so this detriment could not amount to consideration for her husband's promise. However, whether or not you think such a promise should be enforceable, the case for enforcement is a lot stronger if the promisee relies on the promise to his detriment. In the earlier example, this would be the case if my niece took a friend out to Disney World in reliance on my promise to pay her tomorrow. Arguably, she should be entitled to sue me for at least the money she has spent in Disney World, say £60. Her reliance interest, if not for the full £100. So when you argue for or against the enforcement of non-bargain promises, you should discuss the two options. 1. Accept the traditional narrow view of consideration, supplement it with the non-contractual regime where non-bargain contracts are enforced through estoppel. Or 2. Widen the definition of consideration beyond bargained for promises.